The BBI case is set to resume. Let me show you the calendar of how this looks like. Starts tomorrow, which is Tuesday, ends on Thursday. The ruling date will be confirmed. That's why we're saying it is a battle of wits at the Supreme Court as proponents of the Building Bridges initiative seek to resuscitate the constitutional review process. It will be a 3-day marathon hearing from Tuesday to Thursday. The Attorney General, President Uhuru Kenyatta, Opposition Chief Raila Odinga, and the Electoral Commission IEBC will try to overturn the Court of Appeal decision that declared BBI unconstitutional.
The President, the Attorney General, alongside Opposition Chief Raila Odinga and the Electoral Commission have teamed up at the Supreme Court to challenge the controversial Court of Appeal ruling that stopped the BBI reggae. The Supreme Court has locked Tuesday to Thursday as the hearing days for the BBI appeal. All parties in the case limited to only 2 lawyers to submit their case within 45 minutes. The timeframes designated for the different parties have been contested as too short, with various parties appealing to the Supreme Court for more time. The Court of Appeal in August of 2021 upheld the High Court decision that declared the BBI constitutional push as unconstitutional. The appeals court equally held that the President unprocedurally initiated the push to change the Supreme law. The Attorney General leads the appeal to have the infamous reggae tunes rent the air once again. The AG has contested the Court of Appeal decision on the foundation of the basic structure. Kihara Karaoke holds that all clauses in the country's constitution are amendable and that the President, as the head of state, has the right to initiate change to the constitution. With the Court of Appeal ruling that the President can be sued, the AG wants the decision quashed, holding that the President enjoys constitutional immunity. The President, on his part, through lawyer Uhuru Kenyatta, has contested the appeals court verdict on being sued and wanted the decision overturned, as well as the right of the President to initiate changes to the constitution protected. Opposition Chief Raila Odinga and the BBI Secretariat want the Supreme Court to find that there was adequate public participation in the constitution review process and that the BBI Secretariat was the promoter of the constitutional change as opposed to the Court of Appeal finding that the President kickstarted the exercise. President Uhuru Kenyatta has been consistent that the country is on a constitutional moment and that the move to change the Supreme law had just been paused but will be realized in the fullness of time.
And although it encountered some legal obstacles, I say again today that BBI is just a dream deferred. One day, someday, it will happen. Because just as the country cannot survive ethnic majoritarianism and exclusion, just in the same breath, it cannot survive unfair and skewed representation.
The Electoral Commission IEBC on its part wants the Supreme Court to uphold that the Commission was constitutionally constituted with the requisite quorum. The Commission also wants to be distanced from verifying whether the promoters of the referendum bill undertook public participation. IEBC argues its mandate is limited to facilitating the referendum exercise. Samugina Citizen TV, Nairobi.